Justice Sotomayor? Justice Kagan? Justice Gorsuch, any further? Justice Kavanaugh? Justice Jackson?
I actually have a question. I guess I'm just trying to understand what has happened to the eminence requirement in your argument. Because I appreciate that you're saying that we could have a situation in which the state court ultimately requires you to, you say, unconstitutionally disclose this list. But that's not certain to happen. And ordinarily in standing for future injury, for risks of future injury, we require in all other kinds of contexts a really clear showing that the thing you say is going to happen, that you fear is going to happen, is imminent. And so I'm just a little nervous about this, and I'm just wondering, have we created a separate doctrine, a different doctrine for First Amendment? Because we normally don't relax it, I think, in this way.
So I think two responses, Your Honor. First choice has alleged a present injury. If you look at the
chill.
Yes.
Yes. I'm doing your other theory. All right. The chill I get. Yes. The other theory.
So with respect to the pre-enforcement theory, I think this court's most recent precedent on that is SBA list.
Yes.
And what the court said is that when you have a credible threat of enforcement, that means these other injuries are sufficiently imminent. And even accepting the Attorney General's theory that maybe first choice is not immediately subject to contempt, we think that's wrong. But even if that's correct, you do have those other three imminent injuries.
Which are?
They are, sure, the burdens of litigation, the fact of an imminent possibility of a disclosure order for donors.
But that's not imminent, right? I mean, that's many steps away.
So in SBA list, this court considered the possibility of an adverse action to the credible threat in SBA list takes the place of the imminence.
I see. Okay.
Yes, if you have a credible threat. And that makes sense, Your Honor, because
I'm sorry, the credibility of that threat doesn't turn on whether we think the court is actually going to do that. You don't have to show that the court is actually going to do it. It's still a credible threat because...
Exactly. Under Dombrowski, under Steffel, this court has never required criminal defendants and others to show that they might actually be punished, which makes sense, again, because if the law is super unconstitutional, that doesn't mean you sort of talk yourself out of federal.
But isn't it interesting that we don't have credible threat in other areas? I mean, I'm thinking about, for example, Perdomo and, the situation, I'm looking for it in my notes, in which people are saying we're fearing that we're going to have these adverse interactions with ICE. We have evidence of this happening, and the court seems to say not enough. We don't employ some sort of a credible threat analysis in that context.
Sure, Your Honor, and that's actually why we think the First Amendment associational harm here is important in addition to the pre-enforcement, because as you identify, if you have an investigation, the pre-enforcement threat is not going to come into play in that context.
I see.
So we think there are cases like Bantam Books, like Speech First, which respondent identifies, in which pre-enforcement will not be applicable, and this court should make clear that the First Amendment protects those interests and standing as well.
Thank you.
Thank you, Counsel.